Good morning. I'm attorney Gary Finklea. Today I wish to speak with you regarding the substance of a conversation that I had with a client a few weeks ago. It concerns paying for real estate records in local clerk of court's offices. Specifically, my client, who we recently prepared a closing for, called in regard to a document that she received in the mail. It looked like an official document. It requested the payment of $83 in order for her to gain certified copies of her records. I, of course, was sort of surprised at that and asked her to send a copy of the notice that she received. She forwarded that, and thus I'm speaking with you today regarding that, so you will not have the same concerns, questions, or fall prey to this. I'm not going to call it a scam because it's a legitimate service. It's just charging you a lot of money for something that you probably can get for free or for very nominal cost. Following a real estate closing, generally your real estate documents, at least those required to be filed in the public record, are filed. For example, your deed is always filed with the local clerk of court's office. A mortgage is always filed with the local clerk of court's office if you borrow money. However, other documents associated with the transaction are not filed, such as your note or other disclosures that banks and lenders are required to give. When those documents are filed, generally, at least what our office's practice is we will file the original. Then in addition to filing the original, we present the clerk of court with certified copies, or with copies, and the clerk certifies them. All that means is that we provide the clerk a copy of the original document that was filed, and they merely stamp it and seal it with their office's seal or insignia. A certified copy is just as good as the original for most purposes. What happens then is the clerk will take that original document and scan it into their system. And they used to do it the old-fashioned way, of course, by keeping originals. But now what they do, of course, is microfilm it or scan it electronically, so it's available electronically, and they don't have to keep the paper documents. Once that process is complete, then the original is returned generally to the lawyer who closed the loan or handled the transaction. For example, in our office, when we receive that document back, we generally turn around and send the original to the client just for their safekeeping, because we have a certified copy in our file. Generally, this process, at least in Florence, takes 3 to 6 weeks, and generally we return the original to the client within 3 to 6 weeks. However, if this was a loan where title insurance was purchased, it often takes us a little longer in getting the title policy to the client, and so instead of sending multiple letters, one with the deed and another with the title policy, we just wait and send them both together. So generally, in that case, we get the return the original documents to you in 60 or 90 days. This whole time, though, the clerk has the originals, we have certified copies. There's no risk that the transaction is not complete just because you do not have in your hand a certified copy. I really don't know how successful this entity has been in getting clients to pay to retrieve certified copies of documents. In this particular request, they asked for a document fee of $83, and they even put a response date on there, such that there's some sense of urgency for you to respond. Now, there's nothing in their document that's misleading. They merely present factual information about they give you some definitions of what real property is and various types of deeds that they're out there, or how people can hold title to property, such as joint tenancy for right of survivorship, tenancy in common, and other definitions. So the information is not wrong. However, for some reason, when folks receive this, they think they must comply or else their transaction is not complete. Well, that is not true. That is false. And the same documents that this entity wants to produce to you for $83 can be gotten from your attorney's office for free, more than likely, or you can go down to the clerk of court's office yourself and pay for certified copies, and all that you'll end up paying for is a copy of each page that you make, and the copy fee is normally 25 to 50 cents per page in most counties. So I hope this information was helpful. Generally, if you receive anything in the mail following a closing that looks suspicious, call your lawyer to find out. I'm not aware of any of these other anyone else doing things like this, but call your lawyer, talk to them. You paid them to represent you, and that representation generally and often doesn't just stop once transactions close. You know, they're there for you to answer questions after the fact. So that's at least the case here. We appreciate our clients, and we like to help them any way we can. If you have any questions or concerns regarding any matter, whether it's real estate or other type of matter, please feel free to contact us. You can reach us through our website at www.finkleylaw.com. You can call us at 843-317-4900, or please feel free to email me at gfinkley@finkleylaw.com. Thank you and have a great day.